Thank you. Minister Lametti, we know that you had a timeline of 6 weeks to present a bill. However, meaningful consultation could have been done in that time. Some witnesses who testified at the House of Commons Justice Committee stated that the process was rushed, that decisions about the content of the bill had already been made prior to consultation, and Professor Carrie Frock of the National Association of Women in the Law even called the consultation process, quote, a sham. She outlined the process in detail of the Justice Committee, stating, quote, we were consulted by a junior member of the Department of Justice on June 14. We provided a very detailed proposal to them by 5 p.m. that day. But of course, the first reading of Bill C-28 happened on June 17th. The horse was already out of the barn at that point. It was thank you for your input, but it was obvious that it wasn't taken into account in any way whatsoever, quote. How far, Minister, into the drafting process was your department when you asked for input 3 days before tabling the bill? I'm guessing by that time, that by that late date, the bill was already drafted and you may have even taken it to Cabinet by that particular point. So then, if that is the case, what confidence should those witnesses have that their input was taken into account at all?
Well, I think you have to, first of all, thank you for the question. Look, it's an important question. I note that Noll and Professor Frock are amongst the very few critics of the bill, and that's fine. They had a different opinion. They were part of the drafting, not necessarily Professor Frock, but Noll was part of the drafting team of previous 33.1 in 1996. And they were disappointed with the Supreme Court decision. Let me point out a couple of things. First of all, I can read into the record a list of everybody we did consult on this, and
what point the drafting was at, please?
Consultation and thought about this bill began to happen in a variety of different legal circles after the Davio decision. It has been widely speculated that this particular provision was unconstitutional for many years. I can think of a colleague back at McGill who now sits on the Quebec Court of Appeal who was teaching from day one that Davio was unconstitutional. And so there's been a great deal of thinking, there's been a great deal of interaction and consultation in academic circles as well as between the Justice Department and others from the beginning with Davio. So we weren't starting from zero. In terms of having thought about this, in terms of having consulted about this, the Supreme Court gave us a clear path, 2 clear paths, and we did, and I can go through the list. My team, my political team, which is composed of lawyers and experts in criminal law, as well as the Justice Department, did reach out, did at a national, provincial level, sectoral groups to work with them to come to what we felt was the best conclusion in the shortest period of time. And I'm quite proud of the result. The vast majority of groups are in favor of the including victims groups are in favor of the path that we chose. And we think as between the two, we did it right. And we think we have an improvement on Davio, which I think many of us thought was unconstitutional for a long time. So we weren't starting from zero. We had a lot of input prior. We got a lot of input very quickly. And we moved very quickly because that's what a number of you around the table and a number of my colleagues in the House of Commons as well as stakeholder groups were asking us to do.
Okay. Yes, I would like an answer to the question of how far along the process was that drafting process by 3 days to go when consultation was done. So maybe you can answer that. But Minister, I'll go on to deal with the consultation issues. You said that you consulted with, quote, a wide variety of groups, women's groups, victims groups, and this was the way that most of the groups said that we ought to go forward, unquote. My colleague Senator Carignan asked you in June to provide a full list of stakeholders you had consulted with for Bill C-28 and what advice they had given you. You sent him just the already public stakeholder list of names and nothing else. At the Senate's Committee of the Whole in June, you stated this, quote, we consulted about 30 groups and the vast majority of them said this is the best way to go given the guidance of the Supreme Court. They were almost unanimous, quote. So, Minister, I'm wondering what groups in the consultation did not agree with the government's approach on this bill and what were their chief concerns?
To my knowledge, only Knoll was against this particular, the path that we chose. I don't know that they provided a way forward that was constitutional, that would not have fallen into the same kind of analysis that Davio fell under. So that's about it. And I think, as I had said, there was a widespread level of support from victim services groups, from women's rights advocates, from defense counsel, Indigenous youth, academics who study criminal law, members of the bar, from racialized bar, general legal defense bar, lawyers associations and that sort of thing. I thought, and I still think, and particular academics working from a feminist lens, I think we nailed this one correctly, quite frankly, and to my knowledge, only Knoll thought that perhaps we chose the wrong path.
Okay, and Minister, was there a gender-based analysis done on this legislation? And if so, where is it? And I'm also wondering if it's any more reflective of the gender part of the GBA plus analysis than that of Bill C-5, as the GBA analysis done on Bill C-5 hardly mentioned women at all. Yet that Bill C-5 potentially releases abusers with conditional sentences back into the neighborhoods of their female domestic assault victims.
With respect to C-5, I'm very proud of that piece of legislation. A gender-based analysis was done, and conditional sentence orders are only allowed where public safety is not at risk. And that's critically important to underline. That's been a point of real misinformation, I think, on the part of the critiques of the bill. People cite, for example, sexual violence and then say these offenders are going to be out on the street. It is only where public safety is not at risk that a conditional sentence order is possible and where the sentence would have been less than 2 years. With respect to this bill, a GBA plus analysis was done. We're happy to provide it. We're happy to provide it to you. A note that women and girls are amongst the primary victims of the crimes of sexual assault that are committed while intoxicated. So.
GBA plus analysis then would deal with women and girls in considerable detail.
We will give
unlike
you.
Bill C-5.
We will give you that.
Okay, thank you.